Should you leave only $1 to someone that you really intend on disinheriting, whether it's in your will or your trust? That's what we'll be discussing. So this is a technique that some estate planning attorneys like to espouse, and I get the reason why they do it. The idea is you want to take away the argument that you forgot somebody in your will. And so some attorneys will say, to avoid this person that you want to really disinherit, that you really want to make sure doesn't receive anything, could be a child, could be a friend, could be some other relative, to make sure that they never have claim to anything, you'll leave them just $1 because it shows that you thought of them and you're only giving them $1 and that's all they're entitled to, and that's it. And that's what some attorneys have to tell their clients to do. I personally don't like that technique, and I'll tell you why. When you give a beneficiary anything, even $1, what you're doing is you're giving now the right to examine the document. They now have the right to demand the will or the trust because they are technically a beneficiary, even if only a small one, right? So because they're a beneficiary, they have some rights where they can see maybe who else is getting what, and you may not want that. So instead, what we suggest our clients who want to disinherit someone who maybe was expecting to get something, who would usually get something like a child, or any other relative that you're concerned about, is you can specifically indicate in the will or the trust that you've contemplated them, right? You can say, I have a son, his name is Joshua, and for reasons known to myself, I specifically desire that he get nothing. And therefore, he's contemplated, it's shown that you've put some thought into it, that you didn't just forget about Joshua in this example. And so Joshua's just not going to get anything, but even though he's named in it, he's not a beneficiary because it specifically says Joshua is not entitled to anything. And therefore, you've now, I think, killed two birds with one stone. You've shown that you've contemplated, you put some consideration into whether or not Josh should get anything, you decided against it. Now he's not a beneficiary. Now he has no rights to view these documents in their entirety. So I hope that helps. If you were anywhere in the state of Florida interested in estate planning for all ages, Medicaid planning, or probate administration, please give us a call. If you like this video, give it a thumbs up, give it a share, and thank you for watching.